So I mentioned the other day, when you guys read the Linus case, that I could hopefully have the attorneys in that had been involved in that case. We have sort of a combination of that and something else today. DCF attorney Chris Cook, some of you guys may know him because he teaches here writing and legal advocacy as well. And so Chris was actually involved in that case. My colleague Ilya DeFilippis, who's currently at Leahy Clinic, not in court, may show up, who knows, in the next hour. If not, that's fine, because we also have with us attorney Anthony Gagano. And Tony practices both adult and juvenile criminal defense. So he'll be talking to you, too, about a motion that he actually successfully argued this morning before Judge Blitzman. But I'm going to have Chris just sort of summarize the Linus case. Remember what I said to you guys the other day? There was much more to this case than the appeals court opinion that you had read. So we'll start with Chris.
Sure. Unlike Attorney Gargano, I have to give a disclaimer because I'm not self-employed. I do work for DCF. I am here on my own time, and I won't be disclosing anything that's confidential from the record or from the sealed proceedings. Having said that, let me ask you this. What do you know about Linus?
Vaughn briefed it the other day for us. They do this all the time.
Google it real quick.
Doesn't stay in.
I know. I'm not doing this to test you.
Remember, it was the first case we talked about on Tuesday, 2 days ago. Linus. Come on, Laura.
I left my...
Doesn't matter. What do you remember? What do you remember about the parents and about the reason why? Joe knows, he's nodding. And the reason why the appeals court sent it back down. Remember?
Because the department hadn't met their burden of proving current parental unfitness.
And do you know why the department was found not to have met its burden current?
Yeah, because the judge was relying on stale evidence.
Anybody else have any thoughts about that?
What else do we remember about Linus? How did the case start, Laura? What were the inadequacies of the parents?
Was that the one where they were using drugs?
Yeah, they were drug users. What else?
He would beat her, or there was domestic violence. And then his mother, the child went from time to time with them to live with his mother, and his mother was also living with someone who had...
I think you're mixing it up.
Oh, okay.
Another case, but they were drug users when the kids were born. What other issues did they have?
Remember anything about a bond issue? Creating a bond or not having a bond?
Once they were removed from custody and lived with foster parents for a while.
Well, I'll tell you, if Ilya were here, Ilya DeFilippis, she would be saying that a large part of the case was, and I think this was also found on appeal, that the department had essentially not allowed sufficient visitation, and then at trial argued that there wasn't a bond and that there hadn't been sufficient visitation.
And you mentioned that, Laura, when I think you were discussing the case for us earlier, and you were talking about the visitation. And in fact, Ilya had at one point, we talked about with the Jeremy and Isaac cases, the motions for abuse of discretion. She had filed a motion for abuse of discretion based on the parents. She actually represented mom. I can't remember who represented dad. But they were pretty united as a couple. And she had filed a motion for abuse of discretion because they weren't getting visitation. And actually, the judge did not rule on that motion. And you mentioned it when you were briefing the case for us, right, until much later. So that was one issue in terms of these very young children that weren't getting to see their parents, and consequently had also formed a bond with the family that they were living with. So I'll let Chris continue.
And what would happen as background in the juvenile court system, especially that part of Middlesex County, is things are so busy because of various closures and just the fact that there's a lot of business over there. The judge, in an act of what I think the judge thought was efficiency, was essentially, let's hear it all at the same time. But here's a question I have for you. When a motion for abuse of discretion is filed, who has the burden of proof or persuasion? Yes.
The party bringing the action?
Right, and in Linus, that was apparent. And if that motion is being heard while the trial is going forward, who has the burden of proof at the trial? When DCF has a trial to terminate parental rights, who has the burden of proof?
I would say it would be the department.
Right, so imagine this, you've got an ongoing proceeding, and you're hearing two things as the judge. You're hearing a motion for abuse of discretion and a trial, and two different burdens of proof at the same time. Can you imagine some confusion in that? Well, let me tell you, as a practitioner, there's a tremendous amount of confusion in that, because it's very difficult sometimes, and I think Ilya would say the same thing. You know, who is objecting about what right now? Who is failing to meet his or her burden right now? And of course, the burden of proof for a motion for abuse of discretion versus termination of parental rights are also two different standards. Now, the judge didn't do it because she was lazy. The judge did it because she wanted to try to get it all done as quickly as possible for the parents, rather than saying we're going to stop the trial and deal with the motion. But as you learned on appeal, the results ended up not being that good. Now, in an abuse of discretion motion, and this is something you'll encounter in your practice when you graduate, you deal with any government entity. The government has an obligation to do what the statute says it is supposed to do. That's one of the cornerstones of freedom in a democratic society. The government isn't allowed just to act how it feels it ought to act. Every agency has an enabling statute, and within the agency there are regulations, and that's how an agency is supposed to function. If an agency fails to comply with the statute or its own regulations, it is abusing its discretion. Now, as you learn under Jeremy and Isaac, the government has discretion to do certain things, but only within the statute, only within its own regs. So if you believe, representing an outside person, wait a minute, this action is either outside of these regs or is failing to do what these regs say, that's discretion that is abusive. The government is abusing its discretion, and that's when you file that motion. And that is what Ilya did. Ilya's argument was these folks are not getting the visits that the enabling statute and regulations require, therefore the government is abusing its discretion. But it's hard because it's her burden of proof. She has to do two things, as you will do when you're in practice. First, you have to identify, well, which part of the statute is being violated, and or which regulation is being violated. So you have to do some legal research first, because that's really the threshold. You just can't say, I don't like what this agency's doing. I think it's wrong. You have to show there's a violation first. And Ilya was able to do that. She identified the obligation of the department to do regular and ongoing visits, so she had a basis to file the motion for abuse of discretion. When you get out into practice and you want the government to do certain things, the very first analytical step you would always take is, let's look at the statute and let's look at the regs. And lay people will frequently talk about, well, this ought to happen, that ought to happen. But as attorneys, you'll know, wait a minute, the word ought doesn't mean anything. The question is, what is the statute, what do the regulations say? So that's the important background that I think you'll carry out of this class when you start practicing. Now, in the Linus case, the visitation wasn't happening. Now, from the government's perspective, there was a good reason for that. It wasn't done to punish the parents or hurt them. It was just the reality of the case. However, the fact of the matter is, the visits didn't occur, and do you remember what happened on appeal, what the holding was about those visits? Was this the SJC or the appeals court? Do you remember? And you sure about that?
Yeah, they read the opinion where the appeals were sent back
Okay.
on, Chris, but,
Do you remember what, and if you don't, that's fine. I know you briefed this case a while ago. But essentially, the argument was the government can't break the bond and then argue that it's broken. That's one of the important lessons from Linus. And the lesson from Linus to the government was, you have to follow your regs, even if you have the best of reasons why. So here's a question for you. What if the government wants to do something because, let's take DCF as an example. I'm not speaking on behalf of DCF, I'm here in my own time. But let's say DCF wants to do something for the benefit of a child and its regulations don't allow it. What do you think ought to happen? How can that happen? How can it get done? If you represented DCF and somebody said, you know, we want to get this medical procedure done for the child, but it's kind of risky, and our regulations don't allow us to do it, should DCF just say, well, the heck with it. We don't care, let the child go. What should happen?
Get special permission.
Again, please?
You get special permission.
Well, who do you get permission from?
Courts.
Everybody hear that answer? What do you say loudly?
Courts.
You have to go to court. That's what the government has to do when it wants to act outside its regulations, presumably for a good reason. And you see how the balance of powers start to work so well in that level. The executive branch wants to do something that the legislature has said, well, you can't drift into that area. Sometimes the court has said you can't drift into that area. So the executive branch has to appear before the judicial branch. The classic example is extraordinary medical treatment. It's a case, you hear Rogers hearings a lot. But that's an example in which the government wants, the executive branch wants to act outside its discretion for good reasons, because a child needs some extraordinary medical care, but instead has to go to court. So let me ask you this. If you represented this child and you heard your client is about to have some kind of extraordinary medical treatment, what is your first thought? If you want to know the agency's acting correctly. What's the first thing you're going to look at? Statute?
Regulations.
Can the agency do this? And you might check the regulations. And if you don't have an answer there, what might you next look at in terms of your research? Yes.
Case law?
Case law. You know, has the agency tried to do this in the past? And the answer is probably, because, you know, there aren't that many different fact patterns out there. So you do the case law research and you find out, well, wait a minute. The government can't do extraordinary medical treatment. Not only has the government allegedly abused its discretion, but it's in violation of case law. So your argument is now not just abuse of discretion, but you're able to cite a case. And you're saying the executive branch is acting in violation of what the judicial branch says it can do. So do you think your case is now even stronger? Sure it is. Of course it is, yeah. Because you've got case law. You're not asking the trial judge to say, well, do you think it's outside of the regs or not? You're able to say, look, the SJC has already looked at this question. You can't do extraordinary medical care, Your Honor. Here's the case law. When you appear in front of a trial court judge, even if you've done the research and said, well, I know what the statute says, I know what the regs say, the way to be a successful advocate is to do what?
Check the regs and look at the case law.
Get the case law. Because, you know, if I go into court tomorrow and I want to bring an action against DCF, and I say, you know, I've read the regs, Your Honor, this is outside of the regs. Well, the government attorney is going to say, I don't think it is. And then the judge is going to say whatever he thinks. But if you've got case law in your bag, you can say, you know, under these sets of facts, the SJC's already weighed in. Government can't do it, or the government can do it, one way or the other. So that's the final thing. After you've done that threshold analysis, you want to have the case law in hand when you determine whether you're going to bring an abuse of discretion action. Because as advocates, you know, one of the first things you want to do is resolve it without going to court. You want to get on the phone with your government counterpart and say, you know, I just read case X. Have you looked at it? Well, no, I haven't. Well, take a look at it. 9 times out of 10, as officers of the court, you can resolve the matter without litigating it. And if you have to litigate it, you now can advise your client somewhat about your chances of success, because you can say, I've read the case law. This is generally what the trial court is supposed to do. I can't guarantee the judge is going to understand or follow the law, but if she or he does, this is the way it ought to go. And my final point on that is, clients will always ask you, what are my chances? What are my chances? I'm sure you hear that all the time.
Hey, Chris, tell the class what happened after the appeals court sent the case back down to the judge. Do you remember?
Well, a lot of things.
I know.
I'm trying to
I
think
know.
of...
The first was the instruction. Listen, has DCF changed, you know, its goal or not? Should we have a new trial? Do you remember?
We hadn't changed our goal.
Yeah.
We hadn't changed our goal. And DCF continued to take the same position. And what do you think happened? Any predictions? Do you know what ultimately happened? Do you remember what ultimately happened in the case?
They don't, they only have read the appeals court decision of Linus, the decision that sent it back down for the new trial. So they don't know what happened after that.
Since you mentioned the SJC, I'm going to assume that, it was overturned, and then the department appealed, and then that went to the SJC.
Well, the department didn't appeal.
Remember the judge, the appeals court sent it back down and said that there'll be a new trial if the goal is still the same and the department would have to show grievous shortcomings, et cetera, right?
Yeah. Well, the case settled, ultimately. And I'm trying to think of not drifting into confidential.
Yeah, before it settled, I think that she actually, the judge actually found in the parents' favor.
Right.
Do you remember that? So
Yes.
there was another trial, or at least a piece of the trial, from what I remember.
That's absolutely. Please continue.
Yeah, and the judge did the opposite of what she had done first time around, right?
Yeah,
And so actually the department lost at that point.
Right.
Now, the kids were then how old by then?
They were still, I mean, they were preteen, but, they were kids with conscious memories at that point. They knew what was going on. And this is an interesting thing you'll, again, experience as advocates, especially in child protection, because, the underlying focus, as you've learned, is always best interest of the child. And these were parents who were very committed to these children. They were really, in my view, very devoted people. They had certain limitations, obviously, which was the subject of the litigation. So they prevailed, and then they agreed to work out a settlement in the case, and essentially allowing the children to remain in foster care is the best way I can put it, and maintaining certain
Yeah.
visitation rights. So
And it was a testament really to their love for their children, because they realized what it would do after the children were, and they were in separate pre-adoptive homes from what I remember.
Right.
And they each had their own issues from when they were little.
Right.
And it was really a testament to the parents deciding what really was for their children's best interest. Now, the parents could have taken those children home. That's what I'm saying. They won second time around.
Did the children come home, if it's coming back to me now, this was the one, they had the Down syndrome little
The
sister?
third child never was really an issue
Yeah,
with the
but-
third child.
But she took a lot of work. Did the children come home and then the parents realized?
No,
Oh,
It never
no.
happened. The
Oh,
kids
it never
just went-
happened.
It just went right from there.
They realized they couldn't do that to the kids.
Did they give up
So
parental
sad.
rights so that
Yep.
they were adopted?
Yep, yes.
Yes, that's what happened.
Yes.
This is
Yes.
the field that you're thinking about in this class. I mean, imagine you as the attorney investing all this energy, doing your job to be a zealous advocate. I imagine that at some point, you almost have to have not an emotional connection, but you have some passion for the case. You lose a trial, you appeal it, you essentially win,
She won. She won.
and then your client agrees to do what's best for the child anyway. And the great irony in that is, in a case where I'm supposed to show unfitness, my own opinion doesn't matter. That's my job is to support the agency's position. Where they're arguing unfitness, succeeding, failing, and then in the end, the mother acts and the father act in such a way that it's very clear that there was a degree of fitness, because look at what they did for their kids. And I will tell you, whether you're a parent or not, you're all former children. And if you can imagine the difficulty of biological parents saying, even though we've won, we're going to allow our kids to be raised by someone else, it's really a very heart-rendering thing. I mean, all of the practice in this area of the law is heart-rendering more often than not, but this was almost an O. Henry ending to the story. Almost.
It was a case that took so long,
Oh, forever.
so many years.
It did, yes.
Were the kids made aware of what their parents did for them, or? Were they ever told, you know, mom and dad want you, but we think it's best you stay here, or how did they tell the kids that?
I can't say firsthand it was said to the kids, but I'd be stunned if that wasn't said,
Right.
because I happen to know the foster placements were very much on board with bio parents having an involvement.
Yeah.
And that's also part of the element is, you know, you get into these cases, and a lot of times people begin to view this as a property battle. It just happens a lot. It has the feel of a property battle. It's all about my rights, my rights, my rights. And I never fault anybody for that. But the case you're studying here, everybody sort of put that as a secondary issue. The bio parents were able to say, yeah, it is about my rights. But at the end of the day, the rights are empty in meaning to us as parents because we want what's best for our children. That was a really powerful lesson for everybody, I think. Yeah.
Was it a situation where in the beginning, that wasn't really the thought of the parents, and as the lengthy trial went on, they really did see how well the kids were with the foster parents? And
No, it wasn't like that at
that's
all, Mike. No.
That's-
I mean, in the beginning, they had huge issues. They were homeless, they were drug addicts, but they then did the best they could and pretty much complied with, you know, most of the service plan. As I said, they had the other child with no problems in terms of parenting the other child. The parents were always together, very much committed, did everything that apartment was, you know, asked of them. Always loved their children, and always wanted what was best for their children. And I think the ultimate result really showed their parental love.
You know, so many of these cases get to the central question of how much involvement should the government have in these families? You know, are you entitled to be a bad parent in a free society? I think you are entitled to be a bad parent in a free society, what we might call a bad parent. And the hard part, the hard cases are cases like this where you don't have abuse, you've got neglect, and you've got tremendous commitment. By the same token, there's an argument that the children's needs aren't being met, their basic needs are not being met. And those are the cases that always get litigated. You know, the horrific things you read about in the papers, those cases very rarely get litigated. You know, when someone beats a child to an inch of his or her death, if those cases go to trial, they don't last very long. Because the evidence is a tsunami. And most of those don't even go forward. The hard cases you're going to encounter are the ones where there really are good arguments on both sides. And that's why they don't settle. Because both sides realize I've got a shot at winning. And 99% of the times they don't settle. And I will tell you, both Ilya and I have been around for a while, and neither of us would have predicted the outcome in this case. We were stunned.
Yeah.
Absolutely stunned. And I think the parents sort of, I won't say they did it on their own, but they immediately got it. They basically said, you know, this isn't our fault. This has dragged on for years. What are we going to do to these kids? Yes?
So if essentially from the beginning, the parents wanted what was in the best interest of the children, was it more a matter of that they wanted it to be their decision to let the kids stay in foster care rather than the state saying, we're going to...
No,
they wanted
they
back.
They wanted their kids.
So what led to that change? That's what I think
Many,
my first question
many,
was.
many years of the kids living with other parents.
That led to the parents saying they should just stay there. Okay.
Yeah.
Yeah, yeah,
You know,
I think that's what I meant by my
yeah.
earlier question was,
Yeah.
did the length of the trial convince the parents
Length of the case.
that, you know, that they are better off there? And was that what, you know?
yeah, I think they basically said, in a great act of pragmatism, it's been years since these kids have lived with us.
Yeah.
And they've lived with their foster parents all their known life, basically. And that's the nature of the trials. I mean, I don't remember your name. Nicole.
Nicole, entrance with
Right,
Anna.
I know that, we're on a case together.
Oh.
And you know, Nicole is under the same
Ellen.
requirements of confidentiality as I am, but without stating any names, we're on a trial that started last April. So we're coming up on a year-long
Yeah,
trial right
yeah.
now.
Right?
And you know, children have this habit of growing. And a year is a long time in a child's life. A year is nothing percentage-wise of my life, but for a child, a year is a pretty good-sized chunk. Now, our trial has lasted a year because the judge sort of suspended things, thinking that it would settle. Do you think things have settled? No. So we're back at trial again, hopefully to wrap things up. Yeah.
A couple of times you've referred to like conscious memory of a child. At what age does that start? At like 5?
Yeah. Did you hear what Attorney McGovern said?
Sorry.
No.
She's right.
Every child's different.
Yeah.
Depends on the maturity level, the environment, the training.
Think to your own memories, right? The earliest
cognitive
memory
abilities
could
of
be,
kids.
infant, right, Nicole?
You can also argue that, it doesn't matter how young a child is. They're bonded to a family. They've been with that family for most of its life. And then you're going to take them away. Somehow, deep down inside, they know they were rejected. You know what I mean? Like, I have a sister who was bounced in the foster care system for 10 months. She was in 7 homes in 10 months. She was a year old when she was placed, and then she was almost 2 when we got her. And she innately knows
Right.
somehow that she
Right.
didn't belong in places before, and she struggles socially.
Yeah,
So
Exactly.
kids know it doesn't matter how young they are.
exactly.
And then you add on physical trauma. And whether they remember that or not, there's an argument that, the whole chemical aspect of the brain, the tremendous trauma releases certain chemicals, which in fact affects development in a certain direction. There are studies about that. So, the bottom line is the government is a terrible way to raise children. We try to get kids into families as soon as we can because you have stories such as your sister. There's no permanency.
Now, Tony represents older kids who have been charged with crimes, and he's been doing that for a very long time, before CPCS had even
Used to be called
been around.
Master Defenders Committee. I did it for 5 years. I've been practicing 37 years. I can get into first of all, let me tell you this. It's a mortal sin to walk into a courtroom and not be prepared. If you're not prepared, you're going to get, not just you're going to get slammed, but if you're not ready, you don't belong there. So I'm committing a venial sin being here because I wasn't aware I was going to be here today until maybe
I know,
half hour ago.
I pulled them in, I'm
when I got a
sorry.
text.
I thought it would be
So I have
helpful.
nothing really prepared except some personal things I want to share with you if I can. I practice in the Superior Court as well as the District Court, and I do it, about 50% of my practice is in juvenile court. Years ago, I taught high school in 3 different states, and I got out of teaching primarily because of what was happening then, of parents becoming parents being expected to be, teachers expecting to be parent substitutes because of the deterioration that was taking place 35 years ago with families, which is still continuing. So I got out of it, and I became an attorney. My practice up to about 5 or 10 years ago was primarily Superior Court and District Court. And what I learned in Superior Court and District Court is it makes no difference if you're guilty or innocent. The district attorney wants that conviction, and you want that not guilty. And that's the whole fight in the adult court. Unless you have a realistic, my partner, George Murphy, was a district attorney for about 25 years, and he was one of the few DAs that I knew, that if he had a piece of shit for a case, he knew it, he would negotiate it with you, he would be able to move it. But for the most part, 90% of the district attorneys, in my experience, I'm going to speak for myself, that's the way it works. Juvenile court is a whole different, I only do criminal, I do some CRAs, child requiring assistance. You're not going to like this, and I don't think Chris is going to like it either. I don't call it child requiring assistance. It actually is a CRA. It's child requiring assistance petition. I call it crap. I think it's a horrible law, what's happened. I know we have philosophical differences about it, which I won't go any further than that. I have become, when you're on the criminal side, there's an acronym I hear all the time, and I hate it. They call it kiddie court. A very large part, juvie court, a very large part of your practice in juvenile court is educating prosecutors that you're dealing with kids. And the Supreme Court and the Appeals Court, the United States Supreme Court, they finally come to realization that kids' brains are not developed. That a male brain usually develops, if you look at National Geographic about maybe a year ago, it was all about that, a big story about how boys' brains develop about 24 to 25 and women about 20, 21. I'm not an advocate of what's happened with the marijuana laws. I see kids, 70 to 80% of kids who come into juvenile court smoke marijuana on at least a weekly basis. Then you're sitting there wondering why they don't get up at 6 o'clock in the morning to go to school when they're playing Xbox at 2 o'clock smoking a weed. I mean, it's all over the juvenile court. What's happened now is people have asked the juvenile courts to basically intercede and become parent substitutes. And you can see that politically, what's happening. The cases have come down where if a child is convicted of first-degree murder, it's now been determined that they can no longer have life without parole, that they're parole eligible because of the developmental process of the child, which I totally believe in. I understand that, and I accept it. What's now happening is, and I argued this morning, I had a case this morning in front of Judge Blitzman, who I consider one of the best juvenile judges in the state. I have the utmost respect for him. He's one of the few judges that was appointed non-politically because of his background and what he's done. He's just an incredible judge. I had a case this morning, disturbing school assembly, whatever that means, in threats. I had a kid go to school chasing another kid that she was going to beat up and give a beating to, and it created a ruckus. And I won't give specifically what exactly happened, but they charged him with disturbing a school assembly and threats. I filed a memorandum, a relatively new case come down recently, and the flavor I'm trying to give you here is the court's perspective in the juvenile court has now evolved to the point where judges, prosecutors, and defense attorneys are now beginning to understand that the brain of these kids are not developed. To the point where they understand right or wrong, but there's all kinds of other stuff going on with them impulsively, and I'm not a psychiatrist or a psychologist, but you end up playing a big role in trying to present that kind of picture to a judge. This morning I filed a memorandum with the judge, and I just happened to have it with me, which is fortunate. And in Umberto, what had happened was the court basically said that a defense attorney can now file a motion to dismiss prior to arraignment. And the purpose of that is because once a child is arraigned, he or she is going to have a permanent record of that, either a court record, which is called a Kerry, or a criminal record in the system called a Corey. It's going to be there. Even if it's dismissed, they see the arraignment. And that's why I fought this morning to keep this out of, even though my kid that I represented this morning has other issues going on criminally, it was still important for me to preserve that record. And in Umberto, what it basically it says is, and a lot of it was dictated by Judge Gantz, it said protecting a child from the stigma of being perceived to be a criminal and from the collateral consequences of a delinquency charge is important, even when the complaint is supported by the evidence. It basically is giving judges an ability to say, even though a complaint issued and there was probable cause to issue that complaint, I don't think it's in their best interest of that child to go forward. B.M. Blitzman did into it this morning, and he basically said he doesn't think Umberto goes that far, but he gave me what I wanted. Very recently, just this past, to give you a flavor of my argument, she was charged with disturbing a school assembly. The charge is not supported by probable cause. This was my argument. Disturbance of a school assembly, which prohibits the willful interruption or disruption of a school, extends only to activity that so significantly disrupts their function as to impair the accomplishment of the educational goals. It's Commonwealth versus Bohema. The statute prescribes only such activity as actually creates an interruption or disturbance of the normal functioning of a school. In this case, my kid's in the hallway screaming at another kid. A couple of teachers stuck their head out of their classrooms and poked their head back in. So my argument was it wasn't disturbing the normal functioning of a school. So we pretty much get into that. Make a long story short, he allowed it. The bottom line, then we get into, there were some guidelines that just came down very recently from the Obama administration, which I'd like to read to you, if I can find it. Yeah, the Obama administration issued guidelines in 2014 that recommended public school officials use law enforcement only, I'm quoting it exactly, only as a last resort of disciplining students, a response to a rise in zero-tolerance policies that have disproportionately increased the number of arrests, suspensions, and expulsions of minority students for even minor nonviolent offenses. What's happening in the schools, you're going to see it if you practice juvenile law. These kids are suspended consistently. They're kicked out of school for a minimum of 3 days. They fall behind in their studies and they say, fuck it, I'm not going to school anymore. And they don't go. Now they're behind the 8 ball. 90% of the kids, people who are incarcerated in Massachusetts, this is a statistic I just saw recently, I'm not sure if it's true, don't have a high school education. What does that tell you about our society and what's happening? The public schools cannot possibly, I listened to what Chris said about, you get involved emotionally with these kids. I mean, Ilya would tell you, I've been in court almost in tears. I get so emotionally involved with these kids. I can't even tell you. Yet they're fighting for their lives. You've got to bring that passion to you into that courtroom. And what sucks about it is that you are helpless when you're dealing with these families that don't give a shit about these kids. You're blessed when a kid shows up and he's got 2 parents there. But you're often facing a woman, and I'm not pointing fingers at anybody, but a woman shows up, and it happened to be just last week. She's got 5 kids with 5 different men. And you talk about children that they want to belong. They want to know where they came from. You see that with adopted kids all the time, reaching out later in life, looking to see who their biological parents are. These kids are so much in a void, and they're just falling away. And it's happening. And allowing them to we just criminalize marijuana. We're saying to them it's okay. And, just to be a perspective, 20, 30 years from now, I'm not going to be here. My kids are going to be here. This is my political speech to you, I guess. Who's going to lead this country? What's happening to these kids? It is killing me. And I'm telling you, I fall apart here some days. And I just, it's unbelievable. I guess what I'm trying to tell you is this. Bring a passion every day. If you're going to do juvenile law, it's kiddie court, whatever you want to call it. It's a whole different world. And you're going to bring a passion here. You're dealing with minorities. And you're going to you talk about discrimination, you're going to see real discrimination. And what's happening to the minorities in this country, especially in juvenile court. When you get a judge like Blitzman, who's got the balls and the intestinal fortitude to stand up there and say, hey, wait a minute, we need to protect this child. And that means not giving him or her a criminal record, that's what I'm going to do. And he's awesome at it. And he did that for me today. But it gets overwhelming. I take it home with me, and sometimes I can't even sleep. I'm sorry to get emotional, I don't even know why. I just love what I do. I really love what I do. I'm sorry, I never expected that to happen to me here. But I love what I do, I'm just trying to tell you, these kids are fragile. Their brains are nowhere close. They understand right or wrong, so under the McNaughton rule, the criminal responsibility rule, they're criminally responsible for the most part. But so many of them are not competent. I had a child this morning that Judge Blitzman ordered a competency evaluation on. She didn't know what my role was. She didn't know what a judge did. These kids, they don't know. And you've got to be sensitive to that. You've got to get involved with the families. You've got to follow up with these kids to make sure everybody's trying to do what they do. It's a never-ending battle. My heart goes out to DCF. My daughter works for DCF. It's overwhelming what she does. I see it every single day. And I think they're getting a bum rap, but that's for another day. I read in the paper there's 160 kids unaccounted for. What they're not telling you in the newspaper, a lot of these kids are runaways. I'll show up in court one day, and I'll turn to my client, where's your daughter? Well, she took off this morning. That child is now unaccounted for. It's not right, and we're just holding on. But, that's all I can say to you. Don't go to court unprepared. Have a passion. Law is a passion. They say it's a mistress. It's still a mistress to me. I've been doing it 37 years, and I still love it. And you've got to love it. And I know Ilya. I see her every day. I see her in the pits, and that's what we're in. We're in the pits, and you get tired, man. You get tired. But you're here. You're in a great school. I hope my son's going to be going here in September. By the way, trying to get the dean to accept him. But that's all. That's about all I can tell you. That's all.
Thanks,
No,
John.
that was good.
Question?
Ilya, mom
Oh,
for
she has a
Linus.
question.
And, oh, I'm sorry.
Oh, no.
Anyone have a question for Tony?
Yeah, do you ever ask if the judge could have them enroll in services, like treatment services?
Yeah, I am
or-
constantly trying to convince a judge, one in particular, a prosecutor. Middlesex County is a tough county. It's run by Mary Ann Ryan, before there was Jerry Leone. They're tough. They have finally begun to institute pretrial probations or diversion. They've started diversion programs where they actually have an agenda now that if children are charged with very minor crimes with no prior record, they'll divert them prior to arraignment and allow them to take some kind of diversion program. And it works. It's great that they're doing it.
Not processed, though.
We're seeing more and more of it.
Lola's first with the restorative justice
Right.
diversion program. Those of you, I just posted it on
That's-
Facebook. Those of you who are my
that's
Facebook friends would have seen it. But
You're going to see in juvenile court, the judges, they were a different breed than district court and superior, especially superior court. Most of them are compassionate people, even though a lot of them are political hacks, which I won't even get into. But you know, it is what
Tony,
it is.
you're being taped.
Well, you know,
I'm not afraid to say what you want to say.
I'm not afraid to say what I say. You know, there's very few judges that aren't connected. That's the way it is, except Blitzman. But the bottom line is, they go to answer your question. If you could put together something that I had a kid very recently. He got drunk at 17 years. He was 16. He was at a club in Cambridge. He come out totally drunk, got into a fight with the cops, got out of control. He was a kid from the Middle East. His parents were killed there. He was brought to this country. He's with his uncle now, who took him under his wing. The DA was adamant in giving him a record. He ended up going to school. I strung it out. We talk about stringing things. I strung it out for 7 or 8 months. The kid went to school, got a letter from his principal. He was doing great. A bunch of all kinds of things that he gave me. I was able to present it to the district attorney, Sarah Yaffe. Sarah's tough. I call her Niels. She's tough. She got it. She said, she got up in court. She said, Your Honor, I'm recommending pretrial probation. She said, because of these letters. So you get actively involved in trying to get, but look, it's their responsibility. You got to kick them in the ass. If they don't get the letters, I tell them, that's not my headache. You got to do this. There's a consequence. Do it. And it's so, it's so rewarding when you get a kid that, you see them later, and man, they made it. But there's so few of them, and it kills you. But because it all goes back to family, which again I won't get into because they go back to that environment. When I taught high school, and I taught at Loyola University in New Orleans, and I taught urban education, and I told my students, children are affected by 3 things: environment, heredity, and training. And if they don't have the environment or the training, the heredity is that's what God gives you. But the heredity and training, I mean, you don't have that. Kids fall apart. And it's, it's tough. We're trying to keep it together for them, and it's, all we can do is the best we can. But do the best, you become, I'm a social worker to a very large extent, even though I've got no training in it. But you keep trying. So,
Yeah, no, it's true. It's, you sort of become family to these
Yeah.
families. You become family to these children. And they're in court, and a lot of people do care about them in the juvenile court. The juvenile court is about rehabilitation and helping the children. Very different from the district court and the superior court. Absolutely. And I think sometimes the juvenile court doesn't get the respect it deserves. Do you agree with me on that? And we were talking with Judge Blitzman about that very thing. And do you recall when he said to us, the juvenile court justices have the power to send a child, 7 years old, away for life?
No,
Well,
not anymore.
not anymore, but
Close enough.
close enough,
Exactly.
and to terminate someone's parental rights. That's no joke. That is serious power.
Serious power.
Serious power.
It's a capital punishment of civil litigation.
That's right.
That's true.
And that's well put. And when he said that, it really hit me too hard because, I travel around too with the work I do. And when I go into the district court on occasion, I have some friends there from years ago. I don't know if you run into this at all, Tony. But they'll give you a shot. Oh, what are you doing in big people court today?
oh yeah, they call it kitty court.
That bothers me. Kitty court, like it's some kind of joke. It's not a joke. These are children, and the juvenile court and the attorneys that practice there and the department, we're all there to sort of help these children and their families to turn the corner and make a change. Hopefully.
Ilya, before you came here?
Yeah, I was just gonna say that.
Before you arrived, they were asking me questions about the case, and
Okay.
apart from admitting that you kicked my butt, I didn't get into
I wouldn't say that.
I didn't get into specifics about your clients that they might be interested in knowing about, because
Yeah.
I didn't want to disclose things I can't disclose.
Right.
Yeah, when you first met Mom, and if you could describe the issues she had and what the kind of progress that she made,
Right.
I think that would be helpful.
So I represented the mother on this case who was with the father together for 13 plus years. They had 3 children together. So this is a couple that has been united for a long time and actually continues to be. I stay in touch with them. And they had 3 children together, 2 of them who were the subject to the care and protection that Chris and I litigated. So her issues were substance abuse and homelessness.
Yeah.
And I took on the case many moons ago, before Chris was even at the department, if I recall.
I was in a different court.
Yeah, you were in Lawrence.
I was in
That's
South
right,
Lawrence.
you were with the department but in a different court. And only one child was involved at that time, then the second child came. But in any event, the issues always were the same. It was substance and homelessness. Substance for the father of the children, not homelessness for him.
Okay.
He had a very well-rooted family in the Lowell area, but, you know, he was very committed to her, still is. So that's what their issues were. And I remember fighting with the department that homelessness wasn't a grounds to, you know, remove children or even, you know, seek to terminate their parental rights. But those were her issues. Should I continue?
Yes.
I don't know where to go. I just came back from an eye appointment. I'm all dizzy. I have all these drops in my eyes. I can't see a goddamn thing. It's awful. I don't even know how I got here. Jesus got me here. I killed some kind of animal, too. On the way I did. There were feathers and blood everywhere. It was awful. I did.
You know what's
It was
scary? She's
something.
like this in court.
I hit something. It was awful. I know, I can't see.
I'm sorry.
I don't-
What was it like when the remand came down?
Yeah, that's what I was gonna ask.
Oh,
The
yeah.
question that I wanted to talk about, but I don't think I should, why did the parents agree in the end?
Oh,
Even though they won.
yeah, they won. Because they wanted to do what was right for those kids. Those kids wanted to be adopted, and they wanted to be with those families. That's why. The kids were bonded, the people were bonded, I'm sorry, I'm talking to these folks, I should be talking to you. Yeah.
Take the glasses off.
I can't see a thing, it's awful. The adoptive parents were wonderful people. The 2 boys were the ones that were adopted. The one child who was very disabled was not.
Yeah.
Okay. But the 2 families were just terrific. The department did an amazing job at finding some really good people that are going to help these kids get to far places because of who they are. And so I said to bring them to meet the parents. Maybe that will help move that along. Because these people did at the end win. They wanted those kids back. And so that helped them to meet them and to talk with them and embrace them, and that helped them to finally make the decision, you know, this is what we've got to do for them. It was hard, though. It was hard. When the case was reversed, it was a full panel, too, huh, Chris? It was the full appellate panel
I think so.
that reversed that judge's decision and vacated the decree and gave her instructions on how to handle the next phase of this case once it came back to the trial court. And do you recall, she didn't follow the directions properly, and that was appealed. Do you recall that?
Oh, I do.
It was appealed again, and I want to say 3 times anyway. I mean, my memory is sort of
Yeah, there was mostly
fading
single
here.
justice.
It was single
yeah.
justice appeals on various things. The trial court was given specific instructions, I don't know if they have a case.
They just read the Linus case, so at the end.
Oh, I don't know if you recall
Yeah.
reading the specific instructions a trial judge was to follow to determine whether or not there should be a new trial, and if the judge determines there not to be a new trial, what efforts to make to reunify the
To
children with their
reunify.
families. That's what's coming back to you.
Yeah, that
And she
was
did
it.
not follow that, or so we didn't believe. We appealed that, myself and the attorney for the father. Child's attorney was, children's attorney was supporting the department. And then, if I recall correctly, the single justice agreed.
I think so. We were so confused. The attorneys were so confused.
Yeah.
I remember at one point, I think I either asked Ilya or maybe said on the record, are we now deciding whether there should be a new trial?
Right,
Or
right.
have we begun the trial?
Right, I recall that.
I actually asked the
Right.
question, I mean, it seems absurd when I take it out of
Right.
context.
Right.
But I essentially asked, am I at trial right now?
Right.
Am I engaging in a trial?
Right,
Or am I simply arguing whether there should be a new trial?
that's right.
And in part, I frankly, candidly, I was a little confused, but I also wanted to preserve the record to make it abundantly clear
Yep.
what we were doing.
Yeah, we didn't know where we were, where we stood in the process at that point. She wasn't making it clear.
She was struggling, I mean, she was doing her best too, but, and this is an area of litigation you just don't see anywhere else, because nothing takes so long in other
Right.
areas of the law. And
Right. And I think what happened was, she did give us a new trial,
Yeah.
and that's when she made the decision, well, she did have to. And then she determined that the parents were fit.
Right.
I don't know, it was confusing, it was messy. It was messy. It was very messy, and it was very long. And that was part of the problem, it was very long. I think that was a big part of the problem.
And
In fact,
unfortunately, time passes and you saw, and when you
Yep.
looked at 210-3, and one of the factors is the bonding with
I'll never forget
the,
Judge
foster
Traynor.
parents.
I'll never forget Judge Traynor. It was a sort of similar case back in the
teaches
district
series and
court.
appeals court judge.
Oh, that's right, he's on the appellate court and he teaches here. We were trying a case in front of him many, many moons ago at the district court. That's when the juvenile court was in the district court. And I remember we tried a case in a broom closet. No lie.
There was no space.
There was no space.
There was no separate juvenile court.
There was no separate juvenile court. We were housed in the district court. No lie, it was the 7th session and it was like a broom closet. So I'm here next to the judge like this. The witnesses, oh God.
And did he
And
say something about
He
time? I
said
remember-
something, and I'll never forget what he said. And it was a similar sort of situation where things had been prolonged. And he said, I'm not going to allow the passage of time to create a best interest case for the department.
Great quote.
It's really, really important to, and now the order is that these cases will be tried once the trial begins consecutively, day to day, until conclusion,
Within 30 days.
within 30
They
days.
have to wrap within 30 days.
But wasn't that after the Linus case? That's when all that happened.
Yeah.
And I remember him saying that I'm not going to allow the passage of time to create a best interest case for the department. And that's what happened here, Chris.
That's
It
exactly
was the
what
passage of time.
happened.
The children were
More
settled.
entrenched.
Yeah, the children, and I mean, at the end of the day, I'm happy for the kids. I am. I mean, I am, because they had gone through quite a bit. It was long, and they needed permanency. And I think that's another thing, it's important when you're practicing, I think, to understand that he has a job, I have a job. We all have an interest to protect and to further, and that respect should be given to everyone, no matter what. I think that's really important. Because when it's not, it becomes personal, and then it's not about the client anymore. It's about my feelings towards you, my feelings towards you. That's nothing to do with any of it. It's the person you're representing that you, and to that end, you do what you can to help them and get them from point A to point B as quickly as you can.
And I'll tell you an example in this case that I learned something from was what Ilya describing is what I call more of a holistic practice, in that instead of just saying, I'm going to oppose the department,
Right.
and now that I've won, I'm done, I'll see you later. And there's nothing wrong with that. But Ilya, being what I call more of a holistic approach, took that next step, and I imagine had a candid conversation with the clients and said, what do you really want for your boys?
Yeah.
And apparently, they said, well, this is what we want. And that's the extra step that you don't always see. And I hope you will take that extra step. And no one will condemn you if you don't. I mean, there's nothing wrong with saying, look, I did my job. I prevented the department from meeting its burden. I got to get going now. See you. That's not malpractice.
Right.
But in the end, not only are the boys happy, but arguably the parents, I think, can look back at that act and think we acted out of love.
That's right.
We suffered the loss, but we did it for the benefit of our children. Versus what might have happened. Well, we've ripped the kids out of the foster family. In our heart, we didn't want to, but nobody ever gave us an option. And how horrible might that have been?
Oh, yeah. Catastrophic.
Yeah, I think it would have
I
been.
think they would have been hospitalized.
Yeah, I think so.
I do. I think
Professor
those
Collis,
boys.
I have some questions, if I may. If I
Yes,
could ask the panel.
absolutely.
Thank you. Professor Cook, you had called attention to, the decisions in the Linus case. I'll come back to that in a second. My point was you had called attention to knowing the case that you're going to cite. I had a comment on that, but my question was, we're talking about the goals of the department changing, in this case, during the length of the case going on, the trial going on. I have a question for you. Whose decision in the department is it to change objectives during the middle of the case like that? How is that done? Is it a committee? Is it one person?
You're saying from reunification to termination, when
Yes.
does that happen? I'm going to let
decision is
Chris
that to
answer
make?
that.
Well, it's a clinical decision.
Yeah.
And it is essentially a committee that occurs within the agency to change a goal. All the attorney does is just advise what we think the likelihood of success on the merits is. Sometimes they factor that in, sometimes they don't. But it's a clinical decision based on what we believe is the best interest of the
With
child.
reports from several different people in the agency, including the attorney, is that right?
Yes.
And it could be early on in a case, it could be later, it really depends on
Okay,
it.
thank you. And I have a question, I'm sorry, your name again?
Yeah.
Attorney
Julia.
DeFilippis, by the way, she is a graduate of MSL. She's an MSL alum.
Yeah, 20 years.
Very nice. I have a question for
Sure.
you. Before you arrived, I wanted to get your take on the situation. Professor Cook called attention to checking out the statutes when there's a question and the client is asking you what the likelihood of the success would be. And he commented on always look at the regulations, and the second part of that was always check the case law if you're going to cite it. And through the experience in having been able to observe in juvenile court and through several courts throughout my career here at MSL, had the ability to see, and Professor Cook during the appellate brief class was talking about, his comments were, if you're going to cite a case, you better know it forwards, backwards, and sideways. And I could see from the experience both in juvenile court and the other courts that I've had the experience to observe for the day, the judges have actually taken a recess and gotten off the bench to research whatever you're quoting.
Sure.
So I was simply wanting to ask you, attorney, I was wanting to ask you what you had to say about, in the context of what you did in this case and other cases that you might advise us, looking at the regulations and knowing the case law, and I wanted to see what you had to say about that.
No, I think it's very important to know the statute, to know the case law, to know the regulations. And yes, you are sometimes educating the judge. You know, they don't know everything, except Judge Blitzman is pretty.
He knows everything.
Well, he does, because that's his passion, as you spoke
Reads all
of.
the
It's
time.
his passion. That's what he knows inside and out. The other two judges, not really. And I think that sometimes they look to him outside of our knowledge, and we have to educate them. And they're human, so they're not going to know everything. So yes, I think it's important to know the law, the case law, the regulations. I think it's even helpful to have a copy of it if you're going to make the argument in front of the judge, because you could say, here it is. Would you be so kind to take 20 minutes and go back to your lobby and take a look at it?
In your comment there, and I appreciate it, it's just that I wanted you to, the whole panel to talk about, we've been trained not to school the judge, and in this...
Oh, not true.
Well,
I don't agree with that.
Well, It depends.
Diplomatically.
Diplomatically, yeah.
Exactly.
Diplomatically, not to offend, not to insult, not to act like you, and I know many attorneys that do that, and they
It's
can
always
become
fun to
very.
watch that.
It is fun to watch it,
Yes, it is.
especially with the general.
It happens every day.
It does, with
Somebody-
the general.
Usually it's someone who's fairly new out of law
Depends
school.
on your
That's right.
delivery,
When
Todd.
they're green and they're arrogant, oh God.
Well, you get slammed.
Right, you do get slammed, and you should get slammed. It's arrogance.
What's important is the delivery.
The delivery
There
is
you go.
huge. Delivery is
Delivery-
huge.
You can school a judge, this case I had this morning was threats. And the threat wasn't communicated to the person that they were threatening. They actually told the teacher that they were going to kick somebody's ass. So the issue became whether or not that had to be communicated in order to be a threat. And the case that came down was Commonwealth versus Valentin. I had it with me this morning. Commonwealth versus Valentin said, Judge Blissman didn't know this, it did have to be communicated to the third person, okay, in order for it to still be a threat. So if I say to you, I'm going to kick your sister's ass, even though I didn't say to your sister I'm going to kick her ass, the fact that I said that to you is still a threat in the Commonwealth versus Valentin. When we got into that this morning, I had the case with me, because the case went one step further and said, they still have to prove that I intended for you to communicate it. So it's still a specific intent they still have to prove by me. That's how I won it this morning.
Yeah.
He didn't know that.
And you educated
But
them.
you got to be
And-
careful. I was very careful with him. And I said to him, I said, as Your Honor is aware, Commonwealth versus Valentin, he's up there nodding. I don't even know if he read it, but I happen to have it. And he asked me for it. He said, pass it up to me, and I passed it up to him. And he took a couple seconds looking at it as I'm arguing, he's nodding. So, I mean, diplomatically, it's your approach and how you handle it.
Just
Some
start
judges,
it
you're going
off
to be
with
really
all,
careful.
you know, respectfully, Your Honor. Start it off with respectfully, Judge.
So you didn't say, Judge, if I tell your sister I'm gonna kick your ass.
Because you can see him doing that. Because you can see that.
Well, he's one of the few that would get away with it.
I've seen you get really heated. Real heated.
I had a judge, I was in front of Judge Leone in district court the other day, and I got into a bail argument. She held my client, and we got into it. I mean, seriously got into it. And I kept going. She finally told me to stop. I put my head down, and she knew. Okay, and I was like this, and I just listened. And then after it was all over, I walked away, and she put him in custody. And as I was walking away shaking my head, she actually said in open court, I was shocked. I had no respect for this judge for a long time. She actually said in open court, Mr. Gargano, I want to apologize to you for yelling at you. And I turned to her, and I said, Your Honor, I apologize to you too. But being the asshole I am sometimes, I put the but after it. I said, but, Your Honor. I did it again. And she said, no. She said, that's not why I'm holding her. She's a flight risk. I understand your argument, but she's still a flight risk, okay? I said, got it, Judge. And that was the end of the argument. But you're going to learn this. Some lawyers you get away. Scott Kuhn, I graduated from Mass School. He was one of my students last year. I was in the mentor program. He's now in my office. He said to me, I am never surprised when I walk into a courtroom and I'll see some lawyers get up and get away with everything. My partner, George Murphy, gets away with shit you can't believe. He's a former prosecutor. All the Superior Court judges worked with him. He was the first assistant in Middlesex County for years. So all the Carol Ball, Judge McAvoy, Judge Agnes, all these judges worked with him, and he was their boss. And he gets away with, I watched him do a cross-examination of a state cop the other day, and he's really ridiculing this state cop for being a state cop. Well, you're a state cop, you get away with this, right? And I'm sitting there going, George, but but other people, they don't have that personality or they don't have that reputation, and judges will slam them. I get the reputation of being crazy. So, it's okay, But it works for me. I mean, I tell judges, I don't give a shit. You want to put me in contempt, put me in contempt, and I've been held in contempt.
But the word is reputation, you have to earn that.
You have to earn it.
I had a professor who said to me a great piece of advice. He said, now you're starting your career, and imagine that you have a gallon container, and in that container is your reputation. And that's it, it's a gallon. You're not going to ever add to it. All you're going to do is take away from it.
And don't ever lie to a judge.
That's great.
I had Judge Elam in the Superior Court, and he's a black judge from the Boston Municipal Court. He became a Superior Court judge. He just passed away recently. I had him in the BMC. I did a ton of work. I was pushing out prostitutes and everything else in front of him. And I fought minorities, man. I was there, and he appreciated it. I had a Superior Court case with him. It was a robbery of these kids that went into a pharmacy and they get into the car, they couldn't drive a stick shift. It was a horror show. It was funny as hell. We go in, we're in chambers, and Elam's sitting there, the prosecutor, he said, "How you doing, Mr. Guy?" Again, I said, "Good to see you, Your Honor, it's good to see you." Then he said, we're talking about the kid, and I said to him, "Judge, you know, I've never lied to you." And he said to me, "You don't ever have to say that to me." That's all he said to me. And the DA went, "Whoa." I have never, ever lied to a judge, ever. Recently, Judge Singleton was going to hold me. I was in front of Judge Singleton about a month ago, and after I argued a motion to suppress, he allowed the motion, and he said, "Don't leave." And I stood there, and he said to me, "I'm sanctioning you." I went, "For what?" He said, "Commonwealth versus so-and-so." I said, "Honest God, Judge, who's Commonwealth versus so-and-so?" So he said to me, "You handled that case 3 months ago." And what had happened was this. The case was sent into second session. The kid and I were trying to work out a plea. The kid wasn't happy, so he told me, "You're a public defender. You're a piece of shit. I'm going to hire my own lawyer." Go ahead, huh? That's not a problem. I went in front of Singleton and I told him that. Singleton said, "I'm sending it back to the first session." And what I didn't hear, that Singleton said to me, you are not allowed to withdraw until private counsel files an appearance." I went into first session. I told Judge Schrager what happened. Not hearing what Judge Singleton told me, Schrager said, "You are now withdrawn, Mr. Gargano, and he's going to get a private attorney." Somehow Singleton found out about that. Man, he was going to slam me. I was literally, I don't sweat in court, I sweated. People were looking at me. I was like this. I said, "Man, I have the utmost respect for Judge Singleton." I call him Sevy. I knew him. His name's Severin Singleton. I knew him before he became a judge, and I understand why he was slamming me, because he knows my reputation. I would never do something. I would never disobey a judge. That's a lesson you have to know. Don't ever disobey a judge. And I got the tapes. I listened to the tapes. I said, "Son of a bitch, he told me that I couldn't withdraw." I wrote him a letter, and I told him in that letter, I said, "You've known me." Make a long story short, last week I'm in court. He says to me, "I want to see you at sidebar." I went up to sidebar, and he says to me, "You know, I came in this morning, there was a sealed envelope on my desk from you." He said, "I'm taking that envelope and I'm throwing it in the trash." He said, "I falsely accused you." He said, "I'm sorry." He said to me, "No sanctions." I said, "Your Honor, I want you to take the letter, I want you to open it, and I want you to read it." I said, "It's important for me to know." I said, "You've known me for 37 years. I would never lie to you." So I'm sure he read the letter. What I'm trying to have you take from this is, don't ever make a misrepresentation. Your kid has a record, you know he's got a record, and probation stands up and says, "Your Honor, no record." You cannot make that representation in front of the judge. No record. You can't do it. Best thing to do is keep your mouth shut.
Right.
You don't have an affirmative obligation,
That's
okay,
right.
to correct the probation officer. At least I don't think you do. But, you know, please, if you're going to take anything when you walk into a courtroom from me, is be prepared and don't lie.
Right.
And you won't go wrong. Your reputation comes back 100-fold. The DAs that hide evidence, everybody knows who they are in Superior Court and District Court.
Right.
They play games with you. Okay? I had Carmen Motherway, who's now a DA in Superior Court. I had a case with her in front of a jury. It was a hand-to-hand sale at the Prado Park in the North End. There was no way I could win this case. The day of the trial, during the course of the trial, she ends up coming up with a detective who claims he was there. It was a complete fabrication, and I killed the cop on the stand because he couldn't even tell me the name of the streets in the North End when he told me he was there for 2 months. The jury come back with a not guilty on a hand-to-hand seal. That DA was a piece of shit. She lied. The DA knew it too. The DA knew it too. You know who they are.
Reputation.
Your reputation follows you.
That's right.
And plus, you know you're going to do a terrible job when you start practicing. And just be prepared.
Oh, you are.
And the way that you offset that is by being prepared. You know, and I'll tell you, when I was a new attorney, I had a case in front of Judge Edgerton, new to this area of the law. He's now presiding justice, and he teaches here as well. And he called a bunch of us into his lobby after the hearing. No, I beg your pardon, in the middle of the hearing. Took a recess, called us in the middle of the hearing. And we sat there, and if you know Judge Edgerton, he's fairly soft-spoken, but doesn't waste a lot of words. And we sat there, and he sat at his desk, and we sat in silence, and he sat in silence. Finally, he looked at me, and he said, "So, how do you think you're doing in there?" said, I'm probably not very well. He said,
Good response.
I would agree with that.
I would agree with that.
And he said, maybe we can wrap this up this
That's funny.
You know, I like to think it's because of the fact that we had a terrible case, but maybe I was also doing a terrible job.
That's,
But you know, the reason I mentioned that boring story is to piggyback on what Tony said, which is, the ultimate defense is, I'm prepared.
knowledge.
And if you lose, you lose. I mean, you go in and you have a terrible day because the facts aren't on your side. Okay, you're gonna lose. Big deal. Detach your ego. Don't get happy when you win. Don't get sad when
Right.
you lose. Ultimately, have you brought the facts forward or not? Have you presented the facts in the light most favorable to your client or not? And if you've done both, you're done.
And you will find when you walk in, especially Superior Court, you walk in, you're prepared, you're gonna find your trials are gonna go way down. When you're prepared, you get the deal you want, the district attorneys know it, they know you're gonna be up there trying to kick ass, they know you're coming in there for a fight, they'll say to you, hey, look, it's the school zone case, we'll drop the school zone, you can plea out to blah, 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 blah. It happens. So the more prepared you are, the less trial you're actually gonna have. I'm serious. Because they know people who don't wanna try cases. They know people who are afraid to try cases, and they keep pushing, because they want that conviction. You're gonna see that. It's tough.
It's also amazing
Yeah.
that people don't want to try cases, but it's true.
People are afraid to try. It's amazing. I get referrals because of it. I get lawyers that call me up. I got one BMC case coming up.
The judges don't want to try cases either.
No way.
Tony, they don't
Yeah.
want to try
No, they
cases.
don't. I want to push it out.
No matter what area of law you're in, no matter what you're doing, I mean, I've done a handful of different things other than juvenile law, and it seems to be the same thing. They do not want to make a
They don't.
decision.
I had a trial with Judge Flynn.
They don't wanna make a
She said to
decision.
us in the
They wanna
lobby
be
conference.
appealed.
She actually said to us in the lobby conference, "What are we doing here?" And I looked at her and I said, "Judge, we're going to trial here." She goes, "Oh, well, you know, maybe we can work this thing out." Sure. And I went, "Yeah, okay. Remember Judge Flynn?"
Oh, yeah, I've got a funny story from her too.
I'm not part of this conversation.
My online students need to hear it.
Is this going online?
No, yeah, they're gonna be Twittering it and Facebooking it. You gotta turn that off. It's very dangerous, all this social media.
We're actually almost at the
I
end of
know,
class,
right?
so does
If that's
anybody
what-
I
have
know, political hacks you're calling them. But
Gargano with a G.
right, G-A-R.
Gargano.
What?
Okay, last minute questions. We have like 1 minute left, literally.
All right.
Step.
I was just wanting to address Tony's comments from earlier about how the youth come in and they have all these issues. There's a systems problem. I noticed this, especially in this area. I'm from New Haven, Connecticut. But the systems problem within the communities is that the minorities are isolated.
Oh, yeah.
They're very isolated, and when they come out of their isolation, they're constantly being either profiled or badgered. And then when they're in their communities, they get into so much trouble because there is no services that are out there doing something really positive. In the other communities, they have things that keep the kids available for recreation as well as education. And I don't think that it'll get better until someone starts looking at the systems issue part of it. You'll keep less kids out of court if you remedy the diagnosis as opposed to just band-aiding it.
Exactly.
See, but I'm a great advocate of the child not even reaching that point. This is just my political philosophy. I think this country has destroyed families, and it's sad. These kids are coming in. You know, I don't care what you tell me. Okay, you're gonna totally disagree with this, maybe. Boys need men.
Yes.
They need mentors in their life. And in the minority community, regrettably, that's deteriorated to for whoever fault it was, you know, it's happened.
Right.
And it's sad, you know, and we're trying to band-aid it in a lot of ways. And I don't know what the solution is. You know, these kids are joining gangs because they don't have a family unit. You know, it's just really, really tough. And you know, even as an attorney, sometimes you stereotype. I had one kid, I'm sitting there arguing with him, and he leaned over and he said to me, "You're a nigger." I swear to God. And I went, What? I'm looking at him. What do you do? You know, he actually told that to Judge Tyree, who happens to be black. She put him in jail. She gave him a big speech about how, you know, I was trying to help the kid. But, you know, you hear that expression even among the blacks. I had one kid recently called his sister a nigger. They were both black kids. And I said, what did you say to her? And the court officer was right there. I said, don't you ever fucking use that word in front of me again. And the court officer got to me and said, what are you doing? Blah, blah, blah. And like, it became confrontational. It's just, you know, but you ended up, you know, a kid walks into court and he's got his pants down to his ankle, he's got the chains and everything else, got the pony. You're looking at, you can't, I'm a human nature, I'm not colorblind. And you see it, and you can't help but fall into stereotypes to a certain extent. You try to remove yourself from it. And see, I came from a very poor background, so I can relate to a lot of that. I made it for one reason and one reason only. I had two parents that were there that forced me to go to school. You go to school, you're going to get your ass kicked. And it worked for me. But when it gets to the courthouse, it's get to the point where it's deteriorated so bad that you got no choice to get up there and to fight with every inch of your soul for these kids, so they don't get a conviction. Because I tell these kids, you don't know where you're going to be in 10 or 15 years. I use the expression cha-chang, cha-chang. The doors are locked. You want to be, my son's in the Marine Corps. They look back to middle school before he was accepted into the Marine Corps. They look at everything, all the civil service jobs. I said, you might want to be a fireman. You might want to be a cop. You laugh at me when I say that to you, but it's true. She'll tell you, I talk to them in the hallways like this. They have to understand they're closing doors. And I say to them, the mother's with them. I said to a kid today, she dies tomorrow, God forbid. Where are you going? What are you going to? The kid's like this. Because they're 14. It's not fair. They're kids. But you got to try to get them to put themselves in a framework as an adult, and that's so hard to do. It's so unfair to them. So you do everything in your power to preserve their record.
You're right about what you said. When they're in court, that's real deterioration.
It's got to the point where it's bad.
It's real bad.
You see the same kids over and over again.
Same kids.
It's
It kills
also
you.
long term, it's traumatizing for them. And with the trauma, there's lots of, we're researching the effects on the brain of trauma by default of another class. But long term, the trauma creates brain damage.
Yes.
Oh, yeah, absolutely.
And the longer things get
Permanent.
It creates addiction. It creates all kinds of things. I agree.
And I don't think the courts really understand.
See, I am a
that
great
part.
believer in children learn what they live. I've always believed that. You get a kid in a drug den, the kid's going to be a drug addict. I mean, it's all about what children learn. But when we get the kids, it's too late. They've learned, now they're on the street doing the stupid stuff.
Yeah. And it's about keeping the record as clean as
That's what you
can.
gotta do
You
for
just
this.
gotta, do everything you can to keep the record clean. Because it's, like you said, they do look back, and you don't know where this kid's going to be so many years from now. You want to be able
You find the smallest
have to fill out
technicalities.
an
I had a
application,
case
not
recently,
answer yes.
I had the application for the criminal complaint. It wasn't checked at the bottom, the probable cause was found by the clerk. And I have a case right on point. I argued it to Judge Tyree. There were 5 co-defendants. They were chasing these kids on bicycles. It was like a murder case. It was ridiculous. I had it with Judge Tyree. She said, the 4 corners, I have to dismiss it. Everybody's congratulating me. That wasn't the point. The bottom line was, those are the rules. They didn't follow the rules. I should win. The kids should get off. It's the way I believe in the system. It's the system. We have I tell that to DAs all. I tell to judges. I get into arguments with judges over evidence. I said there are rules of evidence. Okay, it's like playing checkers or playing chess. We have rules. Why have rules if we're not? There's a rules of evidence. There are rules of criminal procedure. If we don't follow those rules, that's the game. Those are the game rules. We got to play within those rules. Some judges don't. And that's where you have the hardest part, is when the judge is ruling against you.
In the juvenile court.
And they apply. They certainly do.
I'm sorry, guys.
Yep.
We went a few minutes past time. Thank you so much.